Firstly, I would like to extend my thanks to Dr. Lalit for giving me this opportunity, and secondly, for organizing this rightly timed session on labor codes interpretation. So, I am always there for that help, sir. So yeah, and thank you to all our patient audience. We understand that this is the last session, but this code is one of the lengthiest code, and hence we require one of the most engaged panelists. As we have seen, we have a fellow panelist who have delved into the details of each provision. So allow me to take you just a bit back. What was the intent behind this? Code notification and what was the rationale existing before this. So just in a brief, if I can mention, before this OSH code has been gone through a statute specific provisions, and it has inculcated state and sector specific provisions. Now there existed many asymmetry, we can say enforcement asymmetry, given the fact that there were multiple licensing authority. Secondly, we can say that there were many not single forum to approach for any grievance redressal, and hence this systematic deficiency has been addressed here in this code, wherein technology based enhancement has been brought into picture. Secondly, if I can say, the main focus here is to strike a balance between the business interest and also the constitutional right that has been provided to the workmen under Article 21, 23 and 42. So this was a brief background why this code came into picture. Now my fellow speakers have already gone through the details, so I'll just take you through few of the very startling features that has been inculcated through this code. It has got in a structural reform, if I can say. So again, as I already mentioned, there has been a single registration system, there has been a licensing system wherein more than 250 employees are employed. You have one single All India license and you have to renew it every 5 years. Then next, if we come to, there has been a worker-centric reform, wherein they have been provided with proper occupational safety measures. If I can mention you, this has already been addressed by the speakers also. Proper health examination has to be there, then safety advisory board has to be constituted. So
thank you very much. First of all, thank you, Dr. Basim, for inviting me, and also I thank my management for permitting me to be present here in such a beautiful conference on this important subject. I think everything has been covered by my co-panelists, and it was also, by listening to them, it was also learning for me on many things. So we have such a senior, like a panelist and the senior most in this field. I can try whatever I know to add a little bit new. I will try to avoid repeating things. So as some of them have already summarized. So if I say my views on this biggest reform in last 6-7 decades, so this has been like constellating all 29 laws into 4 codes, whereas in 20, where PM has tweeted and he mentioned his code, which like minimum government and maximum governance. He also mentioned about ease of doing business. He also mentioned about these are futuristic legislation which will empower enterprises by reducing the compliance, which is very powerful. Next word is red tapeism. I don't know, being in manufacturing industry in last 23 years, this red tapeism, when we manage the compliance at ground level, we manage many things. So why we implement? So he mentioned particularly about that Inspector Raj. These things are taken care in these reforms. He said reforms also seeks the harness the power of technology for the betterment of the workers and industry both, which is very well like put it in a bucket, 4 bucket, which tried to simplify things. Not everything, I will not say everything has been simplified, but yes, seeing the generations, generations, when I'm not saying only human generations, I'm saying generation in terms of businesses moving, in terms of technology moving, in terms of policies moving. Why all these things are moving? Because people need is changing. People needs are evolving in a period of time. So these things has evolved certain based on certain years experience, and people have like grown up with those needs. So as my co-panelist mentioned about the OSH code objective, I'll touch little bit upon it. Like the objective of the act says like to have
Opportunity. You've been patient, you've steered the discussion in the right directions. My job would be to, raise certain points which are pertinent to be discussed, thought through so that you can take it back, because that's the objective of this seminar. My colleagues have gone ahead and spoken a lot about the intricacies in the act, and I like to go into that. But I like to stick to the key core areas which are of concerns for us. So before I start, I always wonder why would we need a code like this? Why? Because this is one code which has the most operational aspect, and therefore rightly the name. And the problem statement in this code is that while it has most of the operational aspect, it has left two open areas. And what are those two open areas? One is its own implementation is dependent on certain prescriptions. Central rules have to come in. The other element that this code has done is that it has conflicted with the state requirements. Now, my colleagues have spoken about leaves, I'll speak about them. But in the whole, what has happened is that as an employer, I am looking at an ambiguity. I know certain things under the code are actually implemented. They have been made live as on 21 November. But then I also know I can't do certain other aspects. And then the most important dilemma as an employer that we have today is that what do I do with conflicts? Because this code is not resolving conflicts. And I like to stick to that point. Now to start with, let me pick up leaves.
Question to our worthy panelists here, and those who want to comment upon these two, which I consider, in my humble opinion, some important features of not just the social security code, but the impact you see the other codes also. Two observations, and I've been saying it, you see, from public fora repeatedly. Why this ambiguity about the definition of wages and all that in different enactments, and which is linked also with the definition of worker. Who is a worker, who is not a worker, and wages. Why can't there be a simple formula applicable that anyone drawing a salary, and that should be mentioned, quantified, even the benefits like allowances and all that could be monetized, and say anyone drawing less than, say, whatever amount, 50,000, will be a workman. Anyone drawing more than 50,000 will be a non-workman. Recently, an appalling judgment of Delhi High Court came, since I am somewhat familiar with aviation also, that a pilot is a workman. Now, how can a pilot be a workman? There are differences in different high courts' opinion. A pilot, you see, gets a salary of about 10 to 12 lakhs per month, but is treated as a workman, because the question arises, what is the nature of the duties performed by the employee? Nature of duties test is very vague test. And even in the case of pilots, pilot who is commanding the aircraft is the supreme authority. Supposing there is a pilot on the flight, he is commanding the flight, he is the commander of the flight, and his managing director is sitting as a passenger. Can the managing director give him any directions? Don't take this route, you take that route, or you offload someone.
Okay, thank you. Thank you, Deepthi, Mr. Akhar. Rather, I really appreciate the fact that you sort of covered the key changes because I had planned to deep dive into a couple of them and I was, at a toss between, do I do generalize it, do I go into specifics? But now I think the choice is clear. Before I start, thank you, Dr. Basim, for this opportunity, as well as CIA and Silf for organizing this event. I want to use this chance to deep dive into a few issues that I particularly face. So, I work at Infosys. We look into employment law issues across the Asia Pacific region. And we are, of course, primarily a services company, IT and ITS services. So we are in a position, and something Mr. Akhar mentioned, where the OSH code has caused a major clash between the state-specific Shops Acts and the code itself with respect to hours of work and leaves and so on. Now, over the last few years when we were looking at the draft version, often we read articles that say these need to be harmonized or there needs to be an alignment done. So today when I take this to our internal, comp and benefits team, they ask me, okay, it needs to be aligned, but how? What are we supposed to do? So I started looking into this, and if you see the OSH code under chapter 7, it governs hours of work, leaves, etc. with respect to a worker, not an employee. This helps us in one way, because for non-workers, you can just continue to apply the framework under the Shops Act. So that's one problem out of the way. Now let's look at workers. If you look at section 120 of the OSH code, and if you guys have a copy of the BEAR Act, I would implore you to have a look at it. It says where an employee is entitled to benefits that are more favorable to him under, say, a law, he shall receive benefits with respect to that matter, notwithstanding the fact that he will receive benefits with respect to other matters under the code. So now what does this mean? What are these matters? I'm going to focus on the leaves to sort of drive home the point that there is really a lot of confusion on this. So let's look at annual leaves under the OSH code. The OSH code says you get 1 day of leave for every 20 days worked, assuming you've completed 180 days of service. So in a year, that's about 18 days. Let's look at a few Shops Acts. Telangana and Andhra Pradesh.
Reading down there that looking at the performance on a day-to-day basis. So in that, in various senses, they are not even controlled by anybody. They are to the extent that they not at the day-to-day work. Right? So therefore, we've been saying this for a long time that to apply shops and establishment law to every kind of shops and offices is misnomer. For companies like Accenture, and I'm not singling out Accenture, I'm saying as a body of companies, perhaps you need a special law looking at the special nuances of how we operate, right? That will be more useful for the company also, and also to people who work in that company. Because Shops and Establishment Act applies to a shop which has few people, and also Accenture which has 350,000 people. And the rules of the game are very different in both these segments. So pertinent points. And of course, the yardstick of misconduct, you're right, completely different. And I'll expand that point to bring it, another point on, and we've discussed this many times with you, that the concept of terminating somebody for performance or refreshing your talent year on year and letting the bottom 5% go is a reality worldwide. But in Indian laws, there's no tacit acknowledgement that the performance and rotation of talent is a real thing.
So I agree actually with on the salary should be the best for the worker, but I will still feel that there has to be some kind of definition on the scope of responsibility should be also there. Like this Delhi High Court decision is really, if everybody wants to be in that category, then 10 lakhs and workman. But more the more advantage. One of the biggest advantage of workman is that the particularly misconduct investigation. Maximum rights they have. So if we categorize on the salary basis 1 month, it will be very difficult for anybody in the office scenario to conduct the investigation. It's a skill investigation for the workers. And we need the particular specific skill. Very few in-house counsel have that particular investigation. Yes, second point is also valid that misconduct in some places where it is a serious misconduct. I am happy that definition in social security has moved away from the criminalization. I have at least under 3 to 4 cases where just because there was no leisure, particularly labor codes, the information, they sent the criminal notice to the MD and I have gone and said sorry and then I have paid the fines. So criminalization, particularly they have moved away, that's good. But yes, they have kept criminalization for the serious offences and we need to have that misconduct defined. And you rightly pointed out that in factory, any miss can lead to a big accident, small miss. But that may not lead to accident in case of other IT company or any service company where there is a miss but there is no actually harm. There can be potential. So I agree with both the points. But some kind of modification is required. But yes, we all know that the definition of worker and this particularly misconduct, almost I will say roughly 60% cases are on that only, in the pending in the court.
That how do they structure this particular leave encashment, which gets accumulated above 30 as a number. How do they actually pay this out towards the end of the year? Again, one way to look at it is, of course, if you look at it from a larger perspective, you're not really provisioning for that amount, you're only provisioning for a shorter number, which is 30 in your books. Because somebody also pointed out that we will have a huge impact on leave encashment payout because of the new definition of wages. So that to that extent, if you look at it from a larger perspective, the wages of an employee will continue to increase. And at the time of separation, if you end up paying somebody, let's say 180 days of leave that has been accrued, that's more of a cost element compared to you just let them accumulate about 30 days and then pay off the additional every year, because that way you're not really taking away any right that has been accrued to them. I think another critical point that we've been observing is that there is a safety committee which was initially only there for factories having more than 1,000 workers. Now we have that number as 500 plus workers for factory and 250 plus for any hazardous occupation. For canteen also, now the numbers come down. So it was previously 250 plus workers and now we have that as 100 plus workers. But then there's a catch here. The language says workers including contract workers. So therefore one will have to be mindful of providing these canteen facilities and also take into account the contract laborers that they may be having. Free health checkup, like most of you would be aware, there is a requirement to provide a free health checkup.